don't go her way, she keeps him from me. And I'm tired of it.
You said she's kept him from you for 3 years.
Right.
All right. Well, I sent it to the friend of the court for a determination of what kind of parenting time is correct. I still have sent it to the friend of the court to determine what is correct. What do you think I'm going to do here today?
I don't know what goes on here today. I don't know that we don't know the process of what happens. Like I said,
you filed the motion.
Talk to anybody.
You filed the motion.
Right.
Well,
and so what information do you need from me in order to send it forward or whatever? What is it that you're trying to come up with now to move forward? What information
I don't give people advice. I listen to what they say and make determinations. I'm not going to give advice on what you need to do. I'm telling you, I sent it to the friend of the court for their evaluation. Cooperate with it. If you do not cooperate with the friend of the court evaluation, all the information I will get will be from her.
Right. That's fine. I get that. I never said I wasn't cooperating with it. I will cooperate with the friend of the court evaluation. What I'm saying now is that what do you need? What information you want from me to, I guess, help you with your decision on what takes place? What I was expecting, I sent it in. You said you read it. What I want is for the next 90 days that I get my son every weekend. And after the 90 days, we split it 50-50. And the 90 days is only to make sure I got enough time to have everything prepared for him. So when he's with me for my time, he's okay. And I have everything that he needs. There is no more. The thing is I don't get any of this time back. None of that time's come back. She was keeping him from me beforehand, before that. Anytime it's something she doesn't agree with. And so what I want is the control to have just as much as control. I want my son. I don't even want to have to deal with her.
Are you done?
Yeah, I'm listening. I'm trying to figure out what the next steps is and what you need from me to prove it. I don't know.
Number one, I don't give advice on when I get from you. That's up to you and your attorney to figure that out. What I get, it's up to her and her attorney to do that. Number two, I referred it to the friend of the court so that they can make some sense and both parties can do whatever they can, provide all the information. The friend of the court will tell you what they want you to do and all that kind of stuff. And at the time that they complete their evaluation, they'll submit a recommendation to the court. If either of you disagrees with the recommendation, you can file within the specific time period that you're allowed. And if you don't agree with it, I'll probably have an evidentiary hearing to determine what is appropriate. That's where the case is right now. As far as you saying you want 50-50, you don't qualify under the standard of Vadvarka for proper cause or change of circumstance to get 50-50 because that changes in an established custodial environment. That is just out there in the law that I'm following. So when you go to the friend of the court, I suggest you follow whatever they need. If they ask you for stuff to prove things, fine. Get it into them because they're going to make a recommendation to me about what is appropriate.
Right, but it sounds like you're telling me what I don't qualify for, but you're not telling me what the qualifications is for that to be moved.
Do you understand? I'm telling you, I don't give advice on what I need. That's
right. No, that's fine. Job. So what do we do from this point? All the information.
You go to the friend of the court, and the friend of the court in the very not too far future will give me a recommendation so that I have some idea. You haven't seen your child for 3 years. I can't stress enough that, if my ex-wife had stopped me from 3 weeks, I would have been in front of the court. Not 3 years. I would have been in front of the court saying, I want that time, not 3 years down the road.
Right. But it also depends on what you believe in.
So you're going to go to the friend of the court, follow the recommendation about when they contact you. Contact the friend of the court today to make sure they have your correct address because they're going to contact you about parenting time and child support. Make sure that they have your address. If they don't have it, they send it and you don't get it, that's your fault, not theirs and not mine.
Yeah, no, they have it.
Well, I'm just telling you, because I had an address in Benton Harbor and you say that's not it, and I don't know if that's what they have. They probably have.
I said that's a mailing address.
You're paying child support. I'm just telling you, if you now come back and say, I didn't get it, and they say, because they're going to tell me where they mailed it to.
Right.
And if you didn't get it, then that's your fault, all right?
Okay.
That's where we're going. So as of right now, there is no other order other than you're going to the friend of the court, and we will be back on this, I'm sure, in the relatively near future when the friend of the court concludes their investigation. And if the parties don't agree on what the friend of the court says, then you'll file an objection within the time period. We'll set up an evidentiary hearing. You'll come in here. If you come in here without attorneys, you're at a disadvantage, but we'll have an evidentiary hearing that is a formal hearing where you must follow the rules of evidence and everything to get it in front of me, and then I'll make a decision. That's where.
Okay. So what was the point of this video call in the first place then?
Your motion. You filed a motion. I had to hear it. I didn't set it up. You set it up.
Okay. Mm-hmm.
Ms. Garber, I didn't give you a chance to say anything, but there's nothing for you to say.